Today we have someone from our very own campus here at UAB. In fact, we have the chair of our Department of History and Anthropology, Carolyn Conley. Carolyn Conley has been at UAB since 1985. She specializes in British and Irish history on the social history of criminal violence. She's published 3 books: The Unwritten Law, Criminal Justice in Victorian Kent, published in 1991, Melancholy Accidents, The Meaning of Violence in Post-Famine Ireland, 1999, and Certain Other Countries, Homicide, Gender, and National Identity in Late 19th Century England, Ireland, Scotland, and Wales, published in 2007. Her current research concentrates on female killers in London from 1671 to 1913. When I knew of her area of interest, I thought she would be perfect to give this talk in conjunction with the traveling NLM exhibit that we have currently on display on yellow wallpaper on Charlotte Perkins Gilman, which is on display in the Alabama Museum of the Health Sciences, and I certainly urge and encourage each and every one of you, if you have time, to see that while it is up, which I think will be on display through March the 25th. At any rate, if you have time after this lecture, please go right next door and see the fascinating banners that are on display that will tell you more about that. At any rate, given Dr. Conley's background and expertise, I think it's safe to say she comes well suited to address today's topic with the somewhat sinister title, In Such Cases There Was a Predisposition to Kill the Child: Mothers, Homicide, and Insanity in Victorian Britain. Please join me in welcoming Dr. Carolyn Conley.
Thank you, Mike. That was a very nice introduction, and it sets things up nicely because what I want to start with is explaining how what I'm doing today fits in a context of my earlier work. I have always had my nice niche in the last half of the 19th century, knew it really well. And this latest project includes material going back to 1671. And as I began to look at these cases, I found one of the first ones which sounded a lot like what I'd done in the 19th century. And I want to read this case. It's from November of 1675. A married woman, and one whose husband is accounted a person of good repute and credit, and with him she lived, to the seeming of those that know them, contentedly and well. It pleased God, whose judgments are unaccountable to his creatures, so for to suffer the devil to prevail upon this poor wretch, as to cause her to perpetrate that horrid action. This woman had been delivered of the child, and was then but newly sitting up after her labor. She was observed for some time before to be somewhat discomposed and distempered in her mind. Those that were about her were fearful at any time to leave her alone, and it had been well if they had continued true to their own fears. The day whereon this tragedy was acted, this unnatural mother orders her nurse upon some errand out of doors, and then takes her little infant in her hands and cruelly thrusts the poor innocent into the coal fire, where it was burned to death. A little while after the nurse returned, she shrieked out and asked who had done it, which the cruel mother presently confessed to be herself, and was thereupon taken into the hands of justice, and at the sessions tried for her life. She was at last cleared by the jury, who judged her not to be of sound mind, before and at the time of doing the fact, and therefore brought her in not guilty. Though the language is archaic, the circumstances are very much like what I had discovered in my work in the Victorian period. A respectable married woman who'd recently given birth shows signs of mental illness. Family members try to keep an eye on her, but when left alone for an instant, she kills her infant. What surprised me was the fact that 17th century juries treated the case with such compassion. It seemed to be a reasonable approach, but I was somewhat comforted that the pattern seems to be consistent. What I didn't suspect was what I would find as I continued my research. After 1709, such cases disappear entirely from the London court records. This is a graph of the number of married women tried in London for killing their own children. And it's really quite striking. Between 1709 and 1822, not a single married woman in London was tried for killing a legitimate child. But suddenly, about the time of the Ascension of Victoria in 1837, the number of such trials skyrockets, raising the interesting question of whether Victorian married women living during the cult of domesticity had been particularly prone to killing their children. This is actually a portrait of Victoria and Albert and the scene of ultimate domesticity. One of the big marks of the portraits of Victoria, especially early in her reign, was the emphasis on her role as mother and wife, always lots of dogs, children, very domestic. This is the sort of Victorian ideal. And yet, the Victorians were aware of the fact that the recorded instance of infanticide was going up drastically. The Victorian press described infanticide as the sin of the age. In 1867, the British Medical Journal suggested that the problem was actually even more widespread than people realized. Those infanticides of which we hear most are probably in number incomparably smaller than the quiet, wholesale, and gradual slaughterings which a little scientific or even unscientific inquiry, if it will take the trouble, may readily discover. A child found dead on a doorstep produces a coroner's inquest, an indignant sensation. But the laying in the grave of some scores of innocents by the gentle, unobtrusive, and gradual administering of soothing syrups and other agents productive of infantile quietism disturbs not the coroner, the press, nor the public. Okay? This is corrected for rates, for population. Of course, the population was going up drastically in the latter 18th and early 19th century, but as you can see, the incidence is going up way, way faster than the incidence of population. So there's clearly something going on here. There are a lot more women being tried for killing their children. And what's exactly causing this is an interesting question. As the British Medical Journal noted, there are infanticides and infanticides. That's a direct quote. The law actually distinguished between married and single women and according to the age of the child. This represents some of the earlier legal issues. A 17th century law stated that any time an unmarried woman was found with a dead infant, she was presumed to be guilty of murder. And the burden rested with her to prove that she was not. And this is a violation of basic Anglo concepts of law. And it's also clear that this law was designed not to stop infanticide, but to stop sexual immorality. The issue was that she was an unwed mother. It's this law that's led to the frequent literary device of the seduced and abandoned maiden on the gallows. But in London, actually, it was relatively rare for women to actually be executed for this crime. Of the 193 women tried in London under this statute between 1671 and 1803, less than a third were convicted, and only 29 of them were actually executed. This blue line represents the number of women who were convicted. The convictions automatically for murder. But, as you can see, it goes down drastically in the 18th century. You can also see, though, insanity, which is the green line, is not there at all. There were only two possible outcomes. Either the woman was convicted of murder or she was acquitted outright. There were no legal options. But in addition to a reduction in the convictions, only 29 of these women were actually executed. What's also interesting is the acquittal reasons. In at least 15 cases where there's clear evidence that the infant had died violently, the head was bashed in, some of them were horrific, the accused was nonetheless acquitted after providing proof that she was married. Not necessarily that her husband was the father, but that she was married. In a typical case from 1681, Mary Naples was indicted for murdering her male infant, but it being proved she had a husband, it was not comprehended in the statute, provided for the preventing lewd women from murdering their bastard children. So she was found not guilty. In other words, she married, it doesn't matter. As I said, over the course of the 18th century, juries grew less and less willing to convict young single women of murder. In 1803, the law was actually changed. The presumption of guilt was removed and a new charge was introduced. You may be familiar with this painting. It's very much 19th century. The title is Sir, Your Child. This is the sentimental portrait of the unwed mother who has been forced into a very difficult situation. The law of 1803 recognized some of the difficulties. Under the law, women charged with murdering illegitimate newborns could be convicted of the lesser offense of concealing the birth of a child. The maximum penalty was 2 years. And in essence, this is a euphemism for infanticide. It's a way you can punish her. She gets 6 months, but you don't have to actually condemn her to death. The new law had a clear impact, but another legal change made illegitimate newborns more vulnerable. This is, you can see, and I'm not very good at corners there. 1803, the law comes in, and suddenly the number of convictions, G stands for sentence of less than 2 years. So they found a nice way to deal with single women who commit infanticide. The 19th century was not easy for illegitimate mothers nonetheless. The new Poor Law of 1832 had made it much more difficult for unmarried women to bring paternity charges against the father. Under the new Poor Law, she had to have a corroborating witness to the identity of the father, which is fairly hard to do. And she also had to bring charges within the first 12 months of the child's life. There are a number of cases of men actually coming to the child's first birth date to say, yeah, you missed it. It's done. So they are really in very difficult position. Furthermore, according to the new Poor Law, you had to enter the workhouse in order to receive any form of social relief. Domestic servants, which was the job for the most women in the 19th century, could not have children. There was simply no provision. The majority of single women accused of infanticide or concealment of birth were domestic servants, many of whom had given birth during the course of the day, left the infant in a privy or hidden somewhere in their rooms, and returned immediately to work. It's really quite extraordinary. Within an hour, they're back at work. After the arrest, they routinely referred to the infant as a miscarriage, even if the child had been full term. We cannot accept the fact that they actually given birth. Given that there was no social service network to care for such children, and the British took an enormous pride in the fact that they did not have foundling hospitals. There's an interesting exchange of letters in the British Medical Journal in which some physicians suggest maybe a foundling hospital would help with this problem. And the journal immediately presses an editorial about what an idiotic, medieval idea that is. We would never do such a thing in Britain. French people have foundling hospitals. Englishmen do not. So there's no provision whatsoever. Denying the pregnancy then was the only means of survival for these women. And London newspapers often ran stories about the number of abandoned infants to be found all over the city. The 1803 legislation meant that unwed mothers accused of infanticide were usually found guilty of concealment of birth. But at least until the late 19th century, that these women might be suffering from temporary insanity was never considered. As one attorney explained, infanticide by an unwed mother was an intelligible act based on an intelligible motive. Of the nearly 500 single women tried in London for killing their children between 1671 and 1913, only 13 were found insane, and 9 of those insanity verdicts came after 1875. I'll explain why that probably is. But in terms of insanity and infanticide, if a woman is not married, it's basically not an option. The assumption is she has a rational motive for what she's done, and she will be punished. On the other hand, 2/3 of married women tried for killing their children were found insane. This huge gap in the middle, of course, as I said, there are no women charged between 1709 and 1822. But once the charges start coming in, you can see the green line. Insanity is almost always the verdict. Only 3 married women were convicted of deliberately murdering their children in London between 1671 and 1913. And the cases in which they were convicted and given lesser sentences were manslaughter cases involving neglect or abuse. So deliberate murder by a married woman automatically means she's insane. Hilary Morgan has argued that puerperal insanity, a term first used by an English doctor in the early 19th century, was a diagnosis particularly attuned to Victorian assumptions about motherhood, that this was, in essence, the disease for Victorian women. Because what could be more at odds with the ideal of motherhood than that a woman would kill her own child? As one physician told a court in a case involving a woman who had cut her son's throat, no woman could have committed the act that she did without she was in a state of insanity. I'm speaking of the act towards herself and the child, and the great cunning that she showed was another symptom of insanity. Cross-examined, in what respect did she show cunning? In throwing us off our guard the very day this occurred. Homicidal intent and cunning together were clear signs of insanity in respect to married women. But while the assumption that married women who kill their children were suffering from insanity is not surprising, that leaves us with the question of why the number of married women suffering from homicidal mania went up so drastically in the 19th century. As you can see, the Victorian period. The answer is varied. First, we may, of course, be seeing an increase in reports rather than in actual events. It seems far more likely, though difficult to prove, that 18th century authorities simply chose to deal with such cases informally. When a respectable married woman killed her child while in a state of temporary insanity, bringing formal charges may have seemed like an unnecessary intrusion into a family already suffering. There are at least two strands of evidence to support this assumption. First, recent studies of women in 18th century asylums found that commitments were almost always arranged by family members, suggesting that issues of insanity were handled privately by the family. This is also in keeping with changes in terms of the intrusion of the state in people's lives was much greater in the 19th century, so they may have just not talked about it. The other evidence for an increase in public reports, rather than in actual incidents, is the Victorian concern with having the law reflect reality. Both legal and medical journals in the 19th century were full of articles deploring the use of legal fictions. Why did judges have to pronounce sentences of death in cases where the death penalty was clearly not going to be carried out? The British Medical Journal had a long campaign to change this. They felt it was inappropriate. Why was the legal euphemism of concealment of birth used in cases where there had been no concealment and the child had clearly been killed? There's some interesting things because technically the charge is concealment of birth. And if the corpse is found in public, sometimes somebody will point out, well, then it really wasn't concealed, was it? And the response is usually, shut up. That's how we do things here. But even though many of the 19th century trials consisted of nothing more than a physician certifying the woman had been insane, the Victorians may have simply preferred that procedures be followed and records be kept. So some of this probably is simply a more careful recording of greater incidents of actually bringing cases before the courts. But another possible explanation comes from a British Medical Journal article from January 1857. This peak is really coming at this point. The dreadful murder last week of 2 young children by their mother draws our attention to the commission by women of deeds deemed horrible crimes by the informed public, but for which in reality they are not properly accountable. The poor woman who put an end to her 2 children's lives, it is admitted on all hands, is a lunatic. Had a medical man, versed in lunacy, witnessed this examination, he would at once have jumped at the conclusion that he saw before him a person who had gone insane in consequence of an attack of puerperal fever. And this, we are given to understand, is actually the case. Those who have seen much of puerperal fever are aware that in the delirium which attends it, the mother but too often directs her violence against her own children. Over-lactation often results, as our associates well know, in insanity, which in a similar manner shows itself in the commission of acts of infanticide. Year by year, we shall see certainly an increasing number snatched from the gallows by the juster ideas now obtaining with respect to the responsibility of women who commit meaningless crimes. Having defined the disease, it was inevitable that the diagnosis was going to be made more often. Interestingly, the theory regarding over-lactation is that literally the milk flies to the brain, and that's what causes the insanity. So this was the medical basis. There was a very considerable literature on puerperal fever throughout the 19th century. The increased number of cases, of course, meant that there was a greater need to understand its cause and its symptoms. At a trial in 1838, a physician explained, "It is not infrequent for women during parturition and shortly after to be affected with a mania peculiar to that state. It is called puerpomania, deficiency of milk, and the milk flowing upwards would very probably cause such consequences." Another physician explained that his patient had a wild, vacant look, not so much as to warrant interference to have her confined in a lunatic asylum, but sufficient to attract notice and make me suspicious of her sanity. She had the peculiar look of puerpomania, which is a well-recognized form of insanity with women about the period of their confinement. It affects them when they are not able to give milk to a child and is the consequence of it. This form of puerpomania develops itself sometimes by acts of violence to the nearest and dearest and to the offspring of the woman. There is no fixed period at which it arrives at intensity, sometimes 1 and sometimes 2 weeks after confinement. There are two forms, the acute, wild, raving, and the other is the melancholy sort, in which there are no delusions. One is violent, coming on unusually within a day or two after confinement, and the other, coming on after the 15th day, is the melancholy type, a recognized form of insanity. There are no delusions, but it leads to acts of violence. I do not believe that persons who have had that melancholy form have sufficient control over themselves to prevent them committing a crime. Even though he had felt this woman didn't need to be committed, she did kill the child when it came to trial. Physicians stressed that the disease was usually short-lived as well as quite sudden. As one physician explained about a patient who had murdered a baby, "I had known the prisoner some time. She's a respectable woman, industrious, steady, and quiet. This was a fine, beautiful baby, and she was in perfect health up until the time of its birth. I was with her every day. She was kind and attentive to the child and exceedingly proud of it. I had not noticed anything strange about her to this occurrence, not the slightest. I have attended many cases of confinement and have seen cases of puerpomania before. It comes on suddenly. I have no reason to hope she will not get right again. It is only a temporary malady. She is a great deal better than when I last saw her, and I hope she will be perfectly well in a short time and in a perfectly sound state of mind." One of the things that is really striking in the cases is how many times, by the time of the trial, the woman has completely regained her senses, and the court releases her immediately. If the finding is one of insanity, and the physician says she is now sane, that's it. Though, during the next pregnancy, that she is monitored by the family. But there is this idea, this happens, it happens quickly, and then it's gone. In addition to the fact that women suffering from puerperal insanity have often seemed devoted to their children, it was also shocking that the women were often from highly respectable families. Notice that in these cases there's a physician who's been attending her all along. This is not standard for Victorian women. You mentioned domestic servants are given birth without any help whatsoever. It is relatively unusual for a midwife to testify in these trials. So these are often women who are respectable and from reasonably comfortable families. Hilary Marlin suggests that one of the features of puerperal insanity was that it seemed capable of striking at the heart of wealthy families, whose womenfolk lived lives of a relative luxury and comfort, just as much as at poorer families. And this is where the yellow wallpaper comes in, or at least to an extent. Though Charlotte Perkins Gilman clearly felt that the enforced rest cure suggested by her doctor only worsened her mental problems. She actually said that it was only when she resumed her writing that she was able to regain her sanity. When I recently reread the yellow wallpaper, I was struck by the fact that the narrator was not confined. She locks herself in the room at the end of the story, but her husband has rented this estate. She's free to roam the ground. She's free to ride horseback. Frankly, when I read the story during a particularly hectic time in the office, I was thinking, please let me have the rest cure. So it was strange to me that this scene is enormously constraining. The resident physician for the City of London Asylum prescribed a cure very much like what Gilman experienced. For moral treatment, when the patient's physical health will permit, change of scenery is indicated. As soon as there is no marked feeble temperature, and if the strength be fairly maintained, she should, weather permitting, be got up, dressed, and taken out daily, but carefully guarded against too much excitement. This course will often induce natural sleep. Faulty habits must be corrected. Fresh air and sunshine outdoors, gentle exercise, amusements, and all forms of diversion will materially aid recovery. and indoor occupation of a light nature should be encouraged. The relatives and friends should not see the patient until she has definitely recovered. And even then, the effects of the visits of the husband and child should be carefully watched. In the melancholic form, these visits are less harmful than the maniacal. Recovery in all cases is gradual and protracted, and in the early stages, the mental state of the patient varies much, but the final result is eminently satisfactory, or about 80% recovery. While Gilman clearly felt that being denied her work worsened her condition, her view is one very much touched by issues of social class, as is the argument made by historians who see patriarchal control in the commitment of women to insane asylums in the 19th and 20th century. Elaine Showalter was one of the leading historians who has argued that, in essence, the insane asylum became a tool of patriarchy. This was the way women who didn't conform to the ideal were treated. Well, this only applies if you're talking about upper middle class women who are well educated and come from comfortably wealthy environments. A recent analysis of the records of asylums from the 19th and early 20th century has discovered that, at least in England, the ratio of male to female patients was consistent with the general population. Women outnumbered men in Victorian England, so they outnumbered men in insane asylums, but by no greater degree. The treatment regimens for both sexes were quite similar. Men were more likely to be violent, which meant they might have a different treatment. But if the patients had the same basic symptoms, the treatments were not based on gender issues. And most telling, the majority of female patients had been committed on the recommendation of other women. Mothers, sisters, neighbors who noticed that the woman seemed to be having problems and suggested a need to be treated. Marlin, in her study, found that the average patient suffering from puerperal insanity, and now this would include those that killed their children and those that did not, stayed at an asylum for 7 months. Even more significant, perhaps, are the number of letters she found where working-class women who had been pronounced cured begged to be allowed to stay at the asylum. While for an upper middle-class woman like Gilman, being forbidden to do meaningful work may have been a serious limitation, for many working-class women, the rescuer was a much-needed break from a life of drudgery. One of the cases in London involved a woman who, in addition to having 9 children, managed the family business full-time. And all I could think of about reading her life was, boy, being sent to an asylum must have been wonderful. So there is this sense that this is very much an issue of class as well. So if women who committed infanticide during a burst of mania or melancholy don't seem to have been the victims of a patriarchal plot, there is no question that puerperal mania was by definition a female disease. As a surgeon testified in 1863, it is the fact that when women are pregnant, they are much more subject to depression. That morbid state of mind is sometimes suddenly developed into a state of insanity, and they destroy the nearest and dearest to them. John Gooch, the physician who first described the disease and coined the term, noted that nervous irritation is very common after delivery, more especially among fashionable ladies. And this may exist in any degree between mere peevishness and downright madness. By the latter part of the century, the medical profession was trying to explain the difference between single women who might kill their infants in response to difficult circumstances and respectable married women who kill their children while suffering from puerperal mania. In 1874, the British Medical Journal published a speech given by John Charles Bucknell, a physician and fellow of the Royal College of Surgeons, who was the Chancery visitor to the West Riding Asylum. In other words, the government sent him out to inspect the asylums to see how patients were being cared for. He pointed out that judges had recently been discussing changes in the law regarding infanticide. Famously, one of the judges had suggested that since nobody knew the value of an infant's worth, the crime probably shouldn't be treated as seriously as other forms of homicide. He was also concerned about their discussion of insanity. If, however, I understand aright, these remarks do not apply to puerperal insanity strictly so called, but to the unhinged condition of mind, which is, with more or less truth, attributed to all puerperal women. And on this point, I think we are in need of accurate medical data. That a woman who can destroy her own child must be in a miserable condition can admit of no dispute. But we meet with such women who, in defense of their own interest, are at the very time able to act with the fullest powers of intelligence and fortitude. We also know that in many of these cases, the act of parturition could not have been difficult or prolonged, hence the domestic servants who give birth and go right back to work. And then an easy process of parturition commonly leaves a woman's mental faculties and her nervous equilibrium undisturbed. The subject is one which richly deserves the most painstaking attention of the profession. If puerperal insanity is intrinsic to female biology, then there's no reason single women and married women should have different experiences. Gradually, assumptions about biology and the essential nature of motherhood meant that the gap between the treatment of single and married women became less acceptable. In 1903, the British Medical Journal editorialized under the headline "The Death Sentence." At a recent assizes, Mr. Justice Bruce passed a sentence of death on a girl of 21 for the murder of her illegitimate child. The prisoner had been strongly recommended to mercy by the jury on account of her youth. In passing sentence, the learned judge was only fulfilling his duty. He must have known at the time that the sentence would never be carried out, and anyone acquainted with his lordship could easily realize how painful it must have been for him to inflict unnecessary suffering on the unfortunate girl. An occurrence of this kind strongly supports the plea of Sir Fitzgerald Stevens that in a proper case, the judge should have the power of mitigating the sentence for murder. This sentence really gets to the heart of the problem. This change is urged with special reference to cases of infanticide, where the distress of mind and fear caused by childbirth is often responsible for the crime. In other words, even illegitimate children who are killed by their mothers are probably victims of insanity. By the early 20th century, non-maternal behavior by any mother was beginning to be seen as a symptom of insanity. In 1913, a prostitute named Annie Kingsley was accused of bashing her 5-week-old daughter's head in and then leaving the child in a hole in the stone wall. When questioned by police, her questions were answered in a plain, matter-of-fact way. She did not display any emotion. When she said, "I've been looking for my child all day," it was said in a conversational manner. There were no tears, no fainting. She appeared to be absolutely indifferent. There was a rather funny expression about her eyes. So this woman is not behaving in the classic Victorian way. She's not crying, she's not fainting. A physician testified, "I've had considerable experience of mothers and children in the infirmary. A mother being callous with a child of this age would certainly not be natural. A large number of the women in the infirmary are fond of their children. I think it was pure temper. She was vicious and cantankerous." Kingsley is then a prostitute. She has murdered her illegitimate child. She has not fainted or cried. She is vicious and cantankerous. Nonetheless, she is found insane. A verdict that would have never happened in the 19th century. Clearly, the rules have changed. So much so that by 1922, the law actually changed. The distinction between married and single women dealing with infanticide was removed. And the definition and cause of puerperal insanity was added to the law. The 1922 Infanticide Act created a separate offense, infanticide, where a woman kills her child under the age of 12 months while, quote, "the balance of her mind was disturbed by reason of her not having fully recovered from the effects of having given birth to the child, or by reason of the effects of lactation consequent upon the birth of the child." In other words, if she kills her child while suffering from the defined symptoms of puerperal fever, she is guilty of infanticide, not murder, and she is insane. In many ways, the 1922 Act at least seems to be the culmination of this recognition that single women and married women are suffering from the same issues. While by no means equal, you can see that the percentage of single women found insane is going up. By 1913, clearly this acceptance is being affected by juries as well as physicians. What's interesting, I think, about this law is that In recent times, feminist historians have attacked the 1922 Infanticide Act as a brutal assault on women's rights. Bridget Bechtold has written, the 1922 reform of the law stigmatized women as unstable due to their very nature and denied that they might have deliberately ended the life of an illegitimate newborn in order to preserve their own options. The actions of British lawmakers demonstrate how gender inequality informed the laws not only by strengthening the prosecution of women, but also by implicitly defining their nature as irrational and robbing them of the agency to choose infanticide from among their narrow range of options. Now, Bechtold represents an extreme position, but this idea that legislation which discusses forms of insanity which are intrinsically female is, by definition, stigmatizing women. I find this a rather strange argument for a couple of reasons. In the first place, the law specifically says that she has to prove that the balance of mind was disturbed. For example, if, and there are a few cases like this, a woman can be shown to have killed her child for insurance money or something else, then she's still guilty and the laws don't apply. So it's not an automatic assumption. Further, loss of agency might be less disturbing than a murder conviction on a purely practical grounds. The problem remains that the diagnosis of puerperal insanity rests on assumptions that women are particularly vulnerable to extreme mental illness shortly after giving birth. And it is a short step from the assumption that women are vulnerable at the time of giving birth to the idea that women are inherently unstable. And this was a problem that historians, especially in the 1980s, were particularly concerned with, as Showalter and Tolt and others. Recent work has challenged this. First, as I said, because certainly in the case of infanticide, it is hard to argue, Bechtold has argued, that these women are acting in a rational fashion and should be judged as fully autonomous agents as opposed to mentally disturbed people. There's also the increasing evidence that insane asylums were not used as ways to keep women down. There are a number of reasons to think this wouldn't have been the plot, because it was enormously expensive. If the goal is simply to keep women down, trust me, the 19th century had plenty of laws to cover that. So I think that really the idea of looking at insane asylums as this key is, I think, problematic, which is not to deny Gilman's experience, but simply to say that Gilman is a very distinctive case and not representative at all. Hilary Marland, whose work on puerperal insanity is enormously important, has pointed out that the incidence of puerperal insanity suggested by 19th century physicians, who suggested about one case in every 500 births, matches the estimate of the incidence of postpartum psychosis in the most recent edition of the Oxford Medical Dictionary. In other words, probably we are simply dealing with the same problem, albeit named. She also points out that the law in the 19th century, at least, seems to have been more humane in dealing with these cases than 21st century American experience. Of course, she's referred to the Amelia Yates case. There are a number of other less publicized cases in which women who seem to be suffering from psychotic breaks have been then convicted of murder. And this, I think, is an interesting problem, because it means that we are so intent on not accepting the possibility that women may at any time be particularly vulnerable, that there is this need to insist on absolute equality before the law, regardless of circumstance. The cruel and unnatural mother is a frightening and rare aberration. But it is striking to me, at least, that a 17th century jury, separated by less than half a century from witch burnings, were more able to accept an insanity defense in such cases than some 21st century jurors are. Similarly, the Victorian ideal of motherhood may have been overly sentimentalized, ordinary as it was, but their treatment of married women suffering from predisposition to kill their children was generally both humane and kind.